Today I'm going to talk about the shotgun pleading. And what is this? This is basically a pleading that pleads facts. Sometimes it also like pleads evidence, because when certain allegations uh, did not relate, are not relevant to the cause of action or the count under which they are pleaded, they can be regarded as evidence and not facts. And in this sense, if a pleading, for example, under a certain count, um, pleads immaterial facts, facts are not relevant to a certain cause of action, then it um, it can risk it can muddle basically the waters, and it can make it can make it really hard for the judge and for the opposite party to know what the allegations are. It might, for example, mention that the defendant was negligent, the plaintiff, but that's nothing more than a legal conclusion, and it's not a correct form of pleading negligence. And this is because if, for example, he pleads a legal conclusion and he states, for example, the plaintiff states that the defendant was negligent, the defendant broke the window and he was negligent in that respect, he actually does not plead more facts that are necessary in order to put the defendant on notice and um, allow him to file a responsive defense, a defense that can counter all the elements that form, let's say, the count, the cause of action of negligence. And then later on, in during the trial, he will be prepared and he will actually have put a defense, a correct defense, in place that will allow him to counter um, the evidence that the plaintiff is going to adduce. Um, Whereas if the allegations were muddled and they were fraught with irrelevant facts and most of it evidence, and the plaintiff did not restrict himself in just pleading the relevant facts of the offense, then the defendant will not be certain as to what are the relevant facts and what are the irrelevant facts, and he may be in danger of filing a defense that does not defend, um, does not actually touch upon the plaintiff's case. And when he will want to file it during the trial, it may be kind of late for him. It may be late for him because there may be in danger of prejudicing the plaintiff's rights if an amendment is requested at this stage of the game, late stage of the game. The other thing is also that the plaintiff can take advantage of this chaos of facts, this uncertain um, uh, pleading of facts, and it can adduce evidence that is somehow controversial because it may be covered by the pleadings and it may not be covered by the pleadings. It may ambush the defendant during the trial, where the defendant will have just filed a certain defense, but he will not have known um, how the facts that were pleaded in a disorganized fashion could amount to another version of events. So there again, you put the defendant at a disadvantage. Or vice versa, the defendant puts the plaintiff at a disadvantage if he files a, shotgun defense. The shotgun approach to pleading happens, for example, when there are legal conclusions. There are a lot of facts that are being pleaded that at some point, I'm not saying that pleading just some background facts or some evidence as well will uh, muddle the waters. But what I'm saying is, if you overdo it, then it's going to be hard because there is the potential uh, risk of no filing a response in defense, filing something else, and then the plaintiff coming later on and interpreting uh, the fact that he claimed, that he pleaded in any way that he wants to, and thus ambushing the the opposite party. And the court actually will not know what is at stake and what is not at stake, what is allowed to be adduced as evidence and what is not allowed to be adduced as evidence. For example, there are a couple of pleadings that will plead, um, for example, in every count, the predecessor counts, and they were just incorporate them in every single count. This will actually result into um, incorporating a lot of immaterial facts into one count, and many cause of actions that have nothing to do with a certain cause of action that um, that they are incorporated into. For example, the one of the parties, say the plaintiff, has pleaded undue influence. It has pleaded conversion. It has pleaded a shareholders agreement. It has pleaded fraud and scienter, which is basically scienter is the knowledge of a fraud that actually separates a normal misrepresentation, an innocent misrepresentation from, and a negligent misrepresentation from a fraudulent misrepresentation, and it um, it is very drastic. Its effect is very drastic on damages and on certain exclusion clauses as well. Thus, it requires an extra pleading of high specific facts that show this punishable, culpable behavior on the part of the fraudster, and the and also the many extras that the victim is afforded as a result of the fraud uh, that he has sustained. Um, that's if you mix all these irrelevant facts to one count, the party the party and then state that it's some sort of it's negligence, or it's if you mix like conspiracy to defraud, conspiracy to injure, and defamation all in like in a count of, like, let's say um, trespass or nuisance like that, or even counts, for example, of a negligent of basically the selling off, selling negligent foreclosure, selling land in a negligent way, and you incorporate them in another section where you actually state the breach of certain conditions, um, without there being an overlap between the negligence and the breach of those conditions, which are purely contractual terms, um, then the other party will wonder why you are um, incorporating all those relevant facts, or undue influence, which basically mentions that the victim was of a frail mind. Why would you incorporate all those into a separate count, and it would thus, um, you know, actually arouse curiosity? He will want to know why you're pleading all those immaterial facts, and in what way do they affect um, the count under which they are pleaded, because they have been incorporated into that count. And if he can know for certain, he'll just put a defense there, and he might risk to you, to your interpretation or to the court's interpretation, um, not being able to put a defense that um, he could have otherwise have put, or he might be um, he might be mischieved as to the facts, whereas there's all this series of irrelevant facts that somehow in the plaintiff's mind call for another version of events, another version of events, which he obviously is going to call for later during the trial, and then the defendant is going to be ambushed, is going to be taken by surprise, because he will not have known what possibly, how possibly all those relevant facts um, constituted, let's say, the count of negligence. So it really shouldn't be about guesswork. That really undermines the principal considerations of pleading, and the fundamental considerations are to let the other party put either party on notice of what his case is, so that they can keep the relevant matters. Um, they can keep them simple. They can keep them restricted, and they can um, they can know how to build their cases. There should not be actually an element of surprise when pleadings are concerned. So thanks very much for attending this video. This is not legal advice under any circumstances, and I will see you on my next video.